I was asked to reflect, like all the panelists, on what are the key challenges and opportunities in the area of business and human rights in the next 5 years. But before looking ahead, let me just take a minute to look back, because I do think that is an important, that this is an important moment in time to also take a little bit of stock of where we were. 5 years ago, and many of you will have been involved at the time, the business and human rights debate was deeply polarized. Fundamental differences existed between the different parties to the debate about just about every point of law or about facts. Mutual suspicion of the motives of the other side of the debate reigned and afflicted much of the discourse. So from the beginning of the SRSG mandate, when John's mandate was established in 2005, it was therefore very quickly became clear that if any progress were to be made on the substance of this very important issue, the dynamics of the debate would have to be radically changed. Extensive evidence-based research was necessary to make unfounded claims and counterclaims more difficult to sustain, and to provide a shared knowledge base on which to proceed. At the same time, exhaustive consultations, and we will have had 47 by the time this mandate ends, with a broad array of stakeholders ranging from Indigenous peoples' representatives to corporate lawyers, were necessary not only to inform the process, although that was clearly very important, but also to establish a basis of trust in the fairness of the approach and help overcome some of that mutual suspicion that reigned so supreme in the beginning. As you all know, the Protect, Respect, Remedy framework was presented by John to the Human Rights Council in 2008, and that was the outcome of the approach that I've just described. And it brought the debate on business and human rights to a place where it had never been before, a shared platform on which ideas and actions can build to achieve cumulative progress over time. This, of course, doesn't mean that everyone now has to agree with each other, but at least the debate will have the same point of departure, and therefore it'll be more easy to have constructive debate about the problems that exist and to find sustainable solutions. The draft guiding principles for the implementation of the framework, and I will not say the O word, operationalization, which we have struggled with for the last 3 years. So these draft guiding principles for the implementation of the framework are due to be posted online on Chris's website next week, we hope. If approved by the Human Rights Council in June next year, they'll bring further clarity of what needs to be done and by whom to avoid and address corporate-related human rights issues on the nature that we saw reflected in these very vivid images earlier. So, looking ahead, it's very much the hope, my hope and expectation that the guiding principles and the framework on which they're based, bringing that conceptual and normative clarity is a great opportunity to advance this debate, because of course having the framework, having the guiding principles are not enough in itself, but they really provide now an opportunity for a much fuller implementation of these norms and standards on which they're based to the benefit of human rights. The framework as a whole also offers the potential of alignment with other initiatives at the international and regional level. We've already seen the ISO 26000 standard, which very clearly in the human rights chapter is very closely aligned with the Ruggie framework. Most of you will know that efforts are on the way in the context of the OECD and also on the IFC to align the relative or the relevant documents that exist within those contexts with the Ruggie framework. So all of this brings great opportunities for an aligned and systematic approach on how to address issues where it's clear who has to do what and what are the measures of accountability and remedies that are necessary for those who are impacted. It's my, I strongly believe that the due diligence at the operational level, it's the due diligence concept, human rights due diligence concept that is already being experimented by with a number of companies, but if that really takes form and that there's a larger uptake amongst companies across the board and across regions, that offers a huge opportunity to prevent, identify and address the human rights impacts of corporate activities. And of course, never to forget the operational level grievance mechanisms. That is such an important part of the framework, and within which this three-legged chair will fall over if we take the last bit on access to remedies away. And that the human rights due diligence and the grievance mechanisms will have the potential to have the most immediate impact on individuals and communities in the protection of their rights. John will step down in June, just when the guiding principles hopefully are adopted by the Human Rights Council. So they'll be very new, and they'll be quite vulnerable for lots of different parties to take them in all sorts of different directions. So one of the challenges will be to sustain the momentum created by the mandate process, and ensuring that the follow-up to the mandate follow-up is adequate to the remaining challenges of interpretation and implementation. Because of course we have this new document, but it will need to be interpreted as we go along, and not all the answers will be in the text that will be there in June. And if the follow-up mechanism or mechanisms or functions, whatever they may be, and that is the prerogative of the Human Rights Council, at least at the international level, to decide what the follow-up should be in the UN context. If it's not big enough, ambitious enough to meet the challenge and the scope and scale of this issue of business and human rights, then there is a risk of regression and fragmentation. And then we might be back to where we were 5 years ago. Thank you.